Kelly, by the way, I can't see the Q&As when I'm screen sharing.
So Charlie, we're live.
Okay, good afternoon. I'm Charlie Sabatino, and we are thrilled to be presenting this webinar on 5 mistakes to avoid in guardianship cases. This panel is sponsored by the ABA section on civil rights and social justice, along with the Commission on Law and Aging, and is one of many in a series of rapid response webinars by this section. We are actively planning additional programming on a variety of issues, so please visit americanbar.org/CRSJ for updates on these programs. During today's program, we urge you to ask questions and of our panelists. And when you do that, use the Q&A function. Do not use the chat function. We won't be monitoring that. If you do not see the controls, please ensure your screen is not idle. I'll be monitoring the Q&As, and so we will do our best to answer your questions, time permitting. While we are sharing a recording of this program with everyone who's registered so that you can see it again later and share it with your networks, which we encourage you to do. So let me start with a brief introduction of our panelists. As I said, I'm Charlie Sabatino, the moderator. I'm the co-chair of the Elder Affairs Committee of CRSJ and former director of the Commission on Law and Aging. And our esteemed panelists include Eric Drogin, who's a fellow of the American Psychological Association and a fellow of the American Academy of Forensic Psychology, and a diplomate and former president of the American Board of Forensic Psychology. He holds a faculty position at Harvard and among other places. Sandra Glazier is an equity shareholder with Lipson Neilson in Bloomfield Hills. It's a Michigan law firm. She concentrates her practice in the areas of family law, probate litigation, estate planning, and probate and trust administration. And finally, Ben Orzeske is chief counsel at the Uniform Law Commission, and he oversees their work on implementation of uniform laws in all 50 states and territories. So we have a terrific panel here today. And we are going to start out with actually a couple of scenarios that we will try to bounce around as we move ahead through this program. First is Mrs. Gray. She is an 84-year-old woman in declining health. She lives alone. You did her will in durable power 12 years ago, and basically a simple will, everything to her 2 children. She calls you out of the blue, wants her entire estate to go to her full-time paid caregiver who she's had for the last 6 months. Soon after she calls, her worried daughter calls you. Mom has been withdrawing increasing amounts from the bank account, she says, with no explanation, and is behind on bills. She claims mom is seriously forgetful and frail, and her hygiene is terrible despite the caretaker. And she thinks the caretaker is a scoundrel, and she's tried to help, but mom refuses the daughter's help or advice. So you're faced with that situation, and we'll look at one more, a different one, a younger woman, 24 years old, who was involved in a car accident and suffered serious injuries with moderate brain damage. She has mild to moderate aphasia and requires assistance with dressing and bathing, but is undergoing therapies and is very slowly improving. She won a judgment against the driver who caused the accident and won $4 million. She has no significant financial management experience to manage that $4 million. And her parents petitioned the court for a conservator to manage her assets. Now, one footnote I'll mention is that when we talk of guardianship throughout this program, we're talking about both guardianship and conservatorship interchangeably, unless we want to focus on one or the other, just terminology. So what kind of mistakes are we covering today? Well, I'm going to summarize them up front here. We're going to go through these, and I'll summarize them again at the end. So, mistake number 1, misunderstanding the realities and nuances of capacity. 2, failing to be creative in crafting alternatives to guardianship. 3, ignoring the role boundaries of the participants' litigation. 4, ceding control to the experts. And 5, overlooking key details of trial preparation. We're going to start out with, of course, mistake number 1, misunderstanding the realities and nuances of capacity. And I'm going to throw this one to Sandy Glazier for starters. Let me ask you, Sandy, when courts or lawyers in their practice face issues of legal capacity, they tend to want a simple yes or no answer in order to proceed. But as the statement of mistake 1 suggests, many miss very important realities about capacity. What is it that they're missing?
Well, first of all, I think people tend to lump all these issues into one basket. And that can be a mistake in terms of assessing whether an individual has sufficient capacity to engage in a transaction. And I think it's also important to understand there's a distinction between delirium and dementia. And the fact that you even have dementia doesn't mean there aren't periods of time that you have sufficient capacity to engage in a whole realm of activities. So delirium can pass, right? It may be cured. It may be the result of a UTI. It may be a medical condition that will resolve. In terms of having somebody who may be diagnosed with dementia, you know, the level of capacity required for a will is very low. The level of capacity required for a very complex contractual relationship will be higher. So it's really important to understand what is the transaction you're involved in, what can the individual actually deal with? Can they provide consent? Can they provide consent if they're supported? Can they do it individually? Or is this something that if you wait a little bit of time, they'll be able to address the issues? You know, some people may have what they call sundowners, maybe trying to get consent or have them engage in a transaction in the afternoon you might not be able to get an answer out of them or for them to process it, but they may be fine in the morning. So we have to assess issues based on the surroundings, based on the individual, based on the transaction. And we can't assume that one size fits all or one diagnosis means they can't do anything at all.
Let's look at Mrs. Gray. And I'll throw this out to any of you. First of all, you can't avoid asking in these cases, who is the client, Mrs. Gray or the daughter? Anybody have any thoughts on that?
Well, to me, it's clear that the Mrs. Gray is the client. You've been contacted, you did her will, she's recontacted you to address her estate planning desires or concerns. Mrs. Gray is the client. And the daughter, while she may be somebody who wants to convey concerns, the duty is owed to Mrs. Gray, not to the daughter. This could get a little complicated if this attorney or it is engaged in multi-generational representation. So Charlie, it is possible that both Mrs. Gray and her daughter are clients of the attorney. But I think that conflict of interest goes beyond what we're trying to address today.
I agree. I couldn't help asking the question though, because it always comes up. So, but in Mrs. Gray's case, there are several issues of capacity, aren't there? I mean, she testamentary capacity, of course, her financial capacity in terms of paying her bills, her ability for self-care, And on top of all that, the possibility of undue influence and exploitation. So where do you start with assessment with someone like Mrs. Gray?
Well, it will depend on which transaction you want to talk about, Charlie, right? So, for her to engage in estate planning, she needs generally, right, to know the objects of her bounty. She needs to be able to formulate a plan and convey it. And she needs to have a generalized idea of what her estate entails. She doesn't have to know dollars and cents exactly what she has, but she has to have a generalized idea, or at least be able to know that she can put her hands on the information and relay that information. When it comes to, do you want to just address that one before we go on? Because I would say people tend to confuse the issue when you're talking about a will. The last topic you raised was undue influence. And undue influence presupposes that the individual has sufficient capacity to engage in the transaction, but the transaction is not the result of their exercise of free will. It is the result of somebody else exerting sufficient pressure on that individual to overcome their will and supplant it with somebody else's.
There's another piece of important information that we're given in that synopsis of Mrs. Gray's scenario. It's that she is refusing the help of her daughter. She's not letting her daughter assist. Well, if she is, she may have a good reason for that, and that might be a good conversation to have. If you have a good relationship with Mrs. Gray, she's established some trust over the years. She's worked with you. A direct question about your daughter seems to be concerned about this and has told us that you're refusing her help. Do you mind telling us what the circumstances are, or why do you think your daughter has your best interests in mind, or do you think your daughter is thinking about something else? I mean, there is an inherent conflict of interest in there, but if Mrs. Gray is still able to have that sort of conversation and you have a pre-established relationship with her, then I think I'd want more information. There is a good place to start.
And when we talk about more information, we're told here that Mrs. Gray is in declining health. That can be relevant to her decision-making capacity. And also, it may not be strictly medical health. There may be other aspects of health that are declining. And so it would behoove counsel to obtain records to have something of a backstop here when counsel is hearing from the kids. Counsel may be hearing from all sorts of persons. And one other thing quickly, when we talk about who is the lawyer for whom, counsel may want to bear in mind that some of these other people are being represented as well. And depending on how things have progressed and what the posture of all of this is, they may need to ascertain that and may need to be dealing with an attorney as opposed to a party at different times under different circumstances.
And I would add to what Eric just commented on. Since Mrs. Gray is the client, it requires her consent to get the additional medical information. We are not permitted to just act as detectives to try to obtain information without obtaining the consent of our client. So we have to have candid discussions with our client, but our client does not always, may not follow our advice or our recommendation to release that information to us so that we can obtain better information in which to try to assess what might be a proper course of conduct.
I would agree and add in conjunction to that it's presupposed that we would get our client's permission, but you may or may not be surprised, Sandy wouldn't, how many caretakers, facilities, other sources of information cough this stuff up without even thinking twice about it. And so part of that may involve when it's getting the records, cautioning these other sources that they should not be providing anything to anyone without the proper permissions, releases, and so forth. I have walked into nursing homes, for example, to do a guardianship evaluation, in some cases not even found anyone to help in the more poorly funded settings. And these places run the gamut in terms of security.
Will that come back and bite you in some way later on, Eric, if you don't get the permission?
Very much so. It may, among other things, impair or destroy your relationship with the person who's been identified as your client. It may undercut your credibility in the course of these and subsequent proceedings. It may, when somebody higher up in the administrative food chain finds out that you obtained records in ways that you might not have, they may be running for cover and maybe ceasing to be as helpful to you as they otherwise might. Those are just a few things. I think, Charlie, you've identified something that is a never-ending source of worry later on, if not handled properly.
What other investigation might you want to do? Well, let's turn to Miss Brown. She's a traumatic brain injury case. Is your approach to assessment going to be different here? And how?
Counsel's assessment or the experts?
Well, those go together because the use of experts depends upon your decision making. So how are you going to proceed?
Well, I mean, if you look at the facts here, the fact that somebody has mild to moderate aphasia and requires assistance with dressing and bathing doesn't necessarily mean that she lacks sufficient capacity. So we have to, and then we have to assess whether to what extent she has capacity. And, you know, I'm sure when we get to one of the other questions about other alternatives to a conservatorship, because this is a significant, we're really talking about, it sounds like the main issue is a settlement from the accident. There may be ways to structure that accident and avoid the need for conservatorship if Ms. Brown is able to handle nominal amounts of money without handling, even though she may not be able to handle $4 million worth of assets. She may be able to handle $4 million worth of assets if she has sufficient assistance, like, so she's invested with a trusted financial advisor. Just because she has suffered a brain injury does not mean she lacks the capacity to be able to deal with these things. So, you know, you may need to run a financial capacity assessment, right? Because that is really, it looks to me like the focus of Mrs. Brown's slide. But it could mean that she has other areas of deficits because she suffered from a brain injury. So it really will depend on what her needs may be and what her abilities are. And those have to each be assessed.
And that's a good segue actually into the next question, which I am going to jump us to. Whoops, how do we end up down there?
There we go. Yes.
Failing to be creative in crafting alternatives to guardianship. And I think I'll start this one off with Ben. And let me ask you, Ben, you know, lawyers who have experience in guardianship cases face the question of whether the individual needs a guardian or doesn't need a guardian. I mean, that sounds like a binary decision. How is the creativity missing that is referred to here?
Yeah, I think a lot of times for those of us who have some experience with guardianship, we tend to, you know, we work with to that as the first solution when it really there are a lot of other things that ought to be attempted first. We have these kind of unfortunate pipelines to guardianship where either, where it's for developmentally disabled children who are turning 18 or people who are being admitted to a nursing home where guardianship, it almost takes on an air of inevitability that eventually this person's going to need a guardian and we're going to have to go get a guardianship. Well, maybe they don't. If we stick with the case of Ms. Brown, I think Sandy hit the nail on the head when she's talking about money management. We're not given the facts about, what Ms. Brown's thoughts about the $4 million are. Is she responsible in the sense that she knows she needs help and she wants to get professional assistance, but she's still capable of making some decisions for herself? Well, that's great. And on the other hand, if she is not responsible and really has no sense of what $4 million means and is talking about, some profligate spending or some things that she wants to do. That still doesn't mean that she needs a conservator to make all financial decisions for her. This was one of the big issues in the famous Britney Spears case where, she had no financial autonomy because the conservator, she had to go and ask permission for everything that any financial decision, any major financial decision that she wanted to make. One of the things that you can do is turn that lump sum into an income. $4 million might translate to after you annuitize it to a lifetime income for someone of Ms. Brown's age and around $10,000 a month and with an inflation adjuster built in to increase each year. Well, that's a lot more manageable. Maybe Ms. Brown is quite capable of making her own financial decisions if we can take away the worry that she's going to spend too much and not have the income last for life. That's you can make things easier short of putting a conservator in charge of every single decision.
Well, and if I could add to that, Ben, people forget that many jurisdictions have, if not most, have the ability of the court to provide a protective order. So if the concern is even with assistance of a financial advisor, that Mrs. Brown would be easily influenced, subject to undue influence or have the potential for scammers, there are alternatives that can be put in place in terms of monitoring for unusual transactions, a protective order that might preclude withdrawals in excess of a certain amount of money, but still provide Mrs. Brown with access and some autonomy to addressing her financial desires with the money that resulted from her settlement. So there are a lot of alternatives. We're not going to be able to cover all of them today, but I think, what we're all on the panel trying to convey is that, guardianship and conservatorship, if we approach it from a plenary type perspective, removes the autonomy of an individual. And their ability oftentimes to control decision-making processes when they still may have the ability at some level to participate. So it's incumbent to try to see if there's a less restrictive option out there that leaves the individual with autonomy. And some have said, some have called this, don't infantilize the individual so that they feel that they are still vested and that their voice is being heard and they have input into what's going on.
Yeah, and that's a major.
And the Uniform Act, Ben, is repeatedly uses the term supported decision making now. And now, not many states have adopted it, but what do you see happening with respect to supported decision making and its meaning and use?
Well, I think people are becoming more used to it. It's becoming a more familiar alternative. The Uniform Act, the full title is the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act. And we put the other protective arrangements in the title because that's supposed to be a focus of the act, is kind of diverting cases from guardianship when a full guardianship or a full conservatorship isn't necessary. And, all of our state statutes, we're used to, they allow limited guardianships, but they're an underused option. because it's again, it's not the default. It's not the easy thing to do. Is just give it all to give all the responsibility to a guardian, make them responsible for the decisions. It's harder to do a protective arrangement because you need to do a needs analysis. You need to figure out exactly what the individual's needs and capabilities are, but that ought to be a requirement, and it is in the Uniform Act. The Uniform Act, by the way, has only been adopted so far in full in 2 jurisdictions, in Maine and Washington State. We're working very hard to get it adopted in other states as well, and there's about 5 other states that have adopted parts of it. But that focus on doing the individual needs analysis and putting together an individual plan for each person who's the subject of that hearing, that's important if you're going to get it right and only take away the rights that are necessary rather than move into guardianship or conservatorship as a first option. And supported decision making is one of the other protective arrangements that is offered as an option in the Uniform Act. And I think most of the people in the audience are probably familiar with the concept. It's something that we all do regularly. I get support from my sister who's a nurse before making any medical decisions, and it's just a formalized arrangement where you can have somebody who's a trusted family member or friend who can help the person with decisions, but still leave the autonomy for the final decision to be with the person themselves rather than with somebody who's hired to oversee them.
Eric, you've had a lot of experience in these cases. Is supported decision-making becoming something more normalized in your work?
Yes, and to some extent, this is a jurisdiction-specific notion, and you'll see that reflected in the chat, by the way. Some are pointing out that, well, the courts are always going to be opting for guardianship, and others are saying, oh, no, not in my jurisdiction. If you're talking about it from the perspective of the physicians, psychologists, and others who may be conducting these things, it is increasingly emphasized in training that you are not simply trying to see if someone, as we've discussed in a binary fashion, needs a plenary guardianship or conservatorship. We're supposed to look at the individual capacities in question. Some state statutory schemes do a very good job of laying out the specific ones that one must address, including driving, voting, things of that, and marrying, things of that nature. Others are broader, but attorneys are more savvy about these things, and as I'm sure we'll be discussing later, they will need to do their part to educate the doctors about what it is that they need to be doing in order to follow the path that's being outlined by other presenters.
One of the comments in the Q&A is the fact that the viewer doesn't often sees cases where the respondent has no attorney. There really isn't anybody who's appointed as a guardian ad litem. Eric, do you see that in your practice? And Ben, do you see state laws permitting that? And we've actually lost Sandy. I think something must have happened technically, so I hope she will be back on soon. But either of you.
Well, I'll just say briefly before Ben weighs in that I'm speaking to you today from Kentucky, where I happen to be this week, and an attorney is routinely appointed at no cost to anyone except the system in order to represent persons in these guardianship and conservatorship cases. In other jurisdictions, not necessarily the case. Let me hand it over to Ben, who can weigh in from the ULC perspective. I'm sure you have a lot more specifics.
Well, it's one of the least uniform areas of guardianship laws. The role of attorneys, not only whether or not a person's entitled to an attorney, but what that attorney is kind of tasked with doing. And sometimes if you're an attorney working in this area, you need to be creative yourself in helping to guide the court, or request the right things from the court in order so that the court can truly help your client. If we look at the example of Mrs. Gray again, The issue in Mrs. Gray's case, we don't have enough information yet to determine it. But the daughter is concerned that she's broadly she's making poor decisions, and so thinks that guardianship is necessary, because if she can't make decisions for herself, if she's endangering herself or others, then we need a guardian to do it. But maybe dig a little deeper. One of the I think most common issues that we see as we get older, all of us, I think, me included, we certainly tend to be a little bit more change resistant. It's more difficult to try something new. And a lot of that, a lot of problems can be caused by some form of substandard housing. If you have somebody who is lived in their home for 30 years and is really loath to make a change, sometimes the health issues, the hygiene issues, the financial issues, all of this might be caused by a house that is dilapidated, falling down around the person, and yet they are unable to make that change, to kind of see that for what it is. That's a situation where the court might say a guardian really isn't necessary. What we need is an assisted living arrangement, so this person can still make their own decisions, and they're not going to like that, to force them to sell their house. But if it's condemned and it's not healthy to live there, and we find them some other living arrangements that are suitable, and hopefully it is as much to their liking as possible, that's going to solve most of these issues. And we don't need to then appoint somebody to make decisions for them. We just need to address the problem, which is the substandard housing.
Eric, how do you deal with the fact of, in using alternatives that either avoid or limit guardianship, things change in the future? In Mrs. Gray's case, let's just say, because we can play it with the hypothetical any way we want, let's just say the testamentary thing was solved. In fact, I mean, one simple initial response with a request like that is simply slow tracking it. Say, okay, let's meet next week and we'll talk about that, and then meet. And as one of the commentators in the Q&A box said, have a cup of tea and ask, how things are going, and find out what she's really thinking. And the whole notion of changing her state might by itself, change to something else. But let's say that problem is not there anymore, and but she does need help managing her finances. And so, and of course, you could use a money management firm, but let's say a limited guardian is appointed just to manage your finances. And then things get worse later on. Are you faced with the judge not wanting this case to come back, so they'd rather just appoint a plenary guardian in the first place?
You might be faced with this, and a lot of that depends on the judge, your access to the judge, and I'm not suggesting ex parte. Sometimes you let things ride a little bit and allow time to be on your side, and sometimes, depending on the case, it's just the opposite. And what you're doing is you're constantly becoming, if not an irritant, at least a steady presence in the lives of the attorneys and other parties who claim to have a stake in these matters. And just as it is with the experts, who are more convincing when they can assert that they met on multiple occasions with an examinee, the same thing will be true of counsel. You'll be having that cup of tea, one would hope, on more than one occasion. I do, however, and I bet this will surface in the chat as well, want to acknowledge the realities of how difficult this can be in some jurisdictions, where it may literally be something that you're doing for the good of the order as counsel. They may throw you a couple of $100 in order to do this. We're all busy these days, and it may be that you don't have time to do this. We may be espousing a standard that is more than some practitioners may be able to support. But that doesn't mean that that's not where we're trying to go. Things indeed may change. Sometimes acutely, timing can be everything. Sandy mentioned the sundowning syndrome, the idea that later on in the day, due to various conditions, people may not be doing as well. But also it can be as simple a matter as dehydration. One of our very best early career doctors, a psychiatric resident, came back and insisted that the individual in question was in no means, but by no means capable of managing their own affairs. Yet when that person showed up to court, they were doing just fine. It was hot. They had not been drinking enough water. The person was in court doing okay. Embarrassing for the doctor, but a good lesson for her and for the rest of us as well.
In a guardianship case, that seems to imply you have to meet with your client more than once.
If possible, and then you have experts, you may have other forms of support, you may be obtaining the records as we discussed earlier, and that's not to mention the host of collateral sources that may be able to provide some information. In particular, caretakers with good and bad advice. Went into a nursing home once, I'm mindful of our time, and conducted an evaluation. They told me, well, you won't be here too long, doc, this one's in a coma. I didn't really like this one as, and here comes Sandy, that's good, as the reference point. But this individual was not in a coma and had a pretty good conversation with me. On the other end, there was somebody who was able, in fact, to communicate with me very well, although they basically had some variant of Lou Gehrig's disease. The only way that they could convey their desires and wishes was with an alphabet tape, where I would move my finger along there, and one letter at a time, they were able to indicate to me that this was the next letter in the word. This person was fully capable. And we were also able to learn, when I talk about the other end of the system, that this person was actually being exploited by a caretaker. In addition to retaining all of their rights, we were also able to rescue them from that particular situation.
That's a good point about the having to point out the letters. A lot of times, judgments of capacity can be based upon laziness of not really going the full 9 yards and really providing the kind of support that they need, which takes a little bit of time.
And what if this person were a primary Spanish speaker, and I got a few letters from them and they didn't seem to make any sense to me at all, and I figured, well, advanced dementia, guess they were right. Got to do your homework.
Yeah. Well, Sandy, looks like we lost you for a moment because of technical reasons. I'm glad you're back. We're going to move on to mistake number 3 now. Although if you have other thoughts about alternatives, I'm sure we'll be able to get to them. I'm going to share my screen again and bump up to mistake number 3, ignoring the role of boundaries of the participants in litigation. And I'm going to start again with Ben on this one. Ben, are the roles of the participants in guardianship litigation any different than in other litigation? And if so, what's so different about it?
They really can be. And again, this is an area where there's very little uniformity from state to state. But the Uniform Act, because of the problems that the drafters were trying to address, made it a system where there are really potentially up to 3 different parties in a guardianship case whose roles are very clearly defined. So the first difference between a guardianship case and other litigation, a guardianship case is not necessarily going to be contentious. It's not necessarily going to be adversarial. You might have guardianship cases where everybody's in agreement that guardian would be helpful in some form, or everybody's in agreement on who that person should be. And so it's the task in those cases is more to craft an appropriate order after doing an extensive needs analysis and capabilities analysis of what that guardianship order should be. And the courts are not necessarily used to this, especially in rural areas. If you have courts of general jurisdiction that are hearing disputes all day between the attorney on either side who's arguing for their client, that court is used to, that judge is used to acting as a referee and not taking a role in active management as much as may be necessary in a guardianship case. With respect to the 3 various roles that are defined in the Uniform Act, the first is a role for an attorney. And under the Uniform Act, and this is not the case in every state, but under the Uniform Act, the subject of a guardianship or conservatorship hearing is entitled to be represented by an attorney, even if they can't afford one themselves. The court should appoint one for them if they request it, or if the visitor, who I'll get to, that's another role, it determines that one is necessary and recommends it to the court. So what's the attorney's role? The attorney's role is simple. It's the same as the attorney role in any other case, and it's to zealously represent your client's interests. You talk to your client, you find out what their wishes are, and you advocate for them in front of the court for the outcome that they desire. And again, in a case where it's not adversarial, that's an easier job. The hard part comes when it might be adversarial, because what the client wants is not necessarily in the client's best interests. And if that's the case, if you have a situation where the client's wishes are not necessarily in their best wishes, or the court believes they're not in their best wishes, you can kind of see that if you ask the attorney to represent both the client's wishes and their best wishes, how you're putting that person in an impossible position. And so for those cases, and for those cases only under the Uniform Act, the court can appoint a guardian ad litem when there is some daylight between what the client's wishes are and what's perceived as the client's best interest. And the guardian ad litem's role under the Uniform Act is to represent the client's best interest and advocate on that behalf to the court. And so if, for instance, the client wants to live independently, but the client has proved that they run into problems or may not be capable of living independently, the guardian ad litem might argue for an arrangement where there is at least some supervision or some oversight rather than a full independent living situation. And then the third very important person under the Uniform Act is called the visitor, and the visitor is not necessarily an attorney. The visitor is somebody who is skilled in identifying and analyzing the needs of the person because of their experience or special training in whatever condition the person who's the subject of the hearing might have. And so in some cases, that visitor might be a physician or a nurse practitioner. In some cases, the visitor might be a social worker. In some cases, the visitor might be somebody with special training in either developmental disabilities or in traumatic brain injuries, but somebody who's qualified to make that assessment and provide a report to the court so the court can make an appropriate recommendation. Now, the elephant in the room, we've got all of these three people in an ideal case. Resources are very limited in most court situations. And so the problem tends to be that even if you have a situation that's contentious and that needs a thorough analysis, sometimes the resources aren't there to do it as ideally you would like under the Uniform Act. And so courts have to cut corners and make do with the limited resources they have. That's part of the reason why the Uniform Act has not been adopted more widely. It's because there's generally a fiscal note that goes along with it, especially in the states that aren't doing very much of this right now. We're asking the courts to do more, and that costs money. And so that's part of the enactment process, is figuring out how you're going to fund those services that are so important to the people who are the subjects of these hearings.
Yeah, good point. Let me ask about the role of the attorney a little bit deeper. One thing you said is that there are cases where everybody agrees that a guardian is needed. Now, and Sandy, let me throw this to you. Should the attorney representing the respondent ever step forward to say, I agree, we need a guardian? Or is that opposite of a zealous advocacy? How do you put those two together?
So the attorney who's representing the client, if the client does not want that admission, can't make that admission, right? They need to zealously represent the individual. And I think we missed a party, Eric, in our discussion, and that's the petitioner. So every person who enters into one of these proceedings, we have to remember the presumption is that individuals have capacity, right? That they have the right of self-direction, and it is the petitioner who bears the burden of proving by clear and convincing evidence that the individual lacks sufficient capacity such that the court needs to take some protective action, whether that be a full or limited guardianship or conservatorship, or whether it be a protective order. Whatever the remedy that the court ultimately determines needs to be fashioned, we have to remember the burden is on the petitioner. So while that burden may shift at some point in time, if we are zealously representing our client, we need to remind the court that the burden is not on our client to prove necessarily they're capable if the petitioner has not proved that they are not.
And you hold to that even when you have a client who you really personally think they need a guardian, but they simply don't want it. You're still going to stick to that?
So, you know, if I am before the court and a hearing, I'm going to stick to that. I might try to recommend to my client that maybe we should go to mediation, maybe we should review other options. You know, so I'm going to explore options before I go to court with my client, but I have to take direction from my client. And so if I am the attorney who is appointed or I've been retained to represent that individual, you know, I can't concede a point they are not willing to have me concede. So it's important to have that communication with the client, so that you understand, just with any other client, what your marching orders are and what the perimeter of consent, right, is from your client.
Eric, does that ring true with your practice?
Very much so. Sandy, you mentioned that you were directing the comment to me in some fashion. But or maybe not, but I see no point of disagreement between us on that. It's about the client. We dance with them that brung us, and we try to effectuate their wishes to the extent possible, just as we do with other persons with whom there may be incapacity, such as child clients. But I should be very clear, we're not equating the child client in terms of capacity or status with persons who may have disabilities and who in fact may have none at all.
I want to respond to one of the comments. Ben, one of the commentators said, "Oh, we're hearing all the good reasons for passing the Uniform Act, but there are downsides that people have supposedly raised." I don't know what they are, but what kind of opposition are you hearing other than the cost?
Well, that's the main one. You know, as far as the Uniform Act, I mean, I'm obviously biased. I think it's the gold standard of guardianship laws, not because it, you know, because of the experience of the people who wrote it, which was not me. It was representatives from all of the major organizations that are involved with guardianship and guardianship law who have plenty of experience, who came to the table and hashed out the policy that goes into it. But you shouldn't take my word for it. It was recommended for universal adoption by the Fourth National Guardianship Summit and by the Senate, the U.S. Senate Special Committee on Aging, who thought that every state should adopt the Uniform Act on guardianship. So we're certainly trying. If there are specific negatives that someone wants to raise, I'm happy to address them specifically. But I'm not aware of any negatives aside from the fiscal ramifications that are preventing enactment.
Right.
So if I could, the negatives that I have heard were presented in recent testimony before Congress in terms of mandatory evaluations and the cost that may pass on, having all these individuals involved may end up being passed on to the allegedly incapacitated individual who feels that they shouldn't have even had a petition brought because they feel that it's not warranted. So there are individuals who feel that all these tiers, when they have assets such that they'll be charged and be responsible as opposed to the court being responsible for the costs, some of those groups have raised concerns. I can tell you Michigan is one of those 5 states that you mentioned, Ben, that has adopted the Uniform Act, but not verbatim. And there's often, while I think it's a great act, the problem comes not in the act, but in the practice. So it's really changing the perspective of the players involved, including the courts, and understanding how benefits can be derived by utilizing the act as opposed to falling on the way we've always done things.
Sandy, you make a great point that even in states that have not adopted the Uniform Act, practices are often far, far divergent from what the law actually says. You also made a point earlier on that I wanted to jump back to about possibly considering mediation. And this sort of deals with, again, alternatives, but that's one that is often, I think, overlooked, particularly in the pre-guardianship situation. Do you all often run into situations where there are feuding families and you can never quite tell who the good guys and the bad guys are? And is that the kind of situation you might want to use mediation for?
Well, it will depend on the facts and circumstances, the individuals involved, and if my client really has the ability to participate in that process. So there are factors that really need to be evaluated in order to determine if mediation is a viable alternative. And also picking the right mediator can be really important, because this may be one of those areas where you need shuttle diplomacy as opposed to putting everybody in the same room. If you have a vulnerable adult who may get bullied by the stronger participants in the process.
Yeah, it's very complex. Let's, for the sake of time, move on and go on to the next issue. We pull that up. Ceding control to the experts. And Eric, I'm going to start this one out with you. I mean, are there always experts in guardianship litigation? Do you need them? And if they are involved, how is it that lawyers in guardianship litigation cede control to them?
Well, that's a nice segue, Charlie, especially given the issues that just arose about the specter of an unfunded mandate for evaluations that some were concerned about with their testimony regarding the Uniform Act. There aren't always experts. And in some cases, they may not be necessary, and in some they might. And of course, we can go deeper into this than just saying, I don't know, it depends where you are. Although it does, it depends on who the players are. It also depends on the quality and availability of the experts. Some jurisdictions will actually pony up for a multidisciplinary team, say a physician and a psychologist and a social worker, who would conduct their individual evaluations and then provide a group report. I think probably quite a few of our participants are aware of some of the concerns that can exist with reports that have more than one signature at the end of them, in terms of getting behind or cross-examining such reports. One of the things that I thought was interesting was this idea of how lawyers in litigation may be ceding control to these experts. What are the reasons for that? There are a number of reasons, and this isn't about picking on counsel. There are some good or more understandable reasons and some not so good reasons. Sometimes it may be that the lawyer handling the guardianship case doesn't have a considerable amount of experience, but the expert may. And if there's anything that we emphasize over and over again, say in my law school class, that the expert is not presumed to be smarter than counsel. That's ridiculous. They went to a school on the other side of the street. Even if the expert is also an attorney, makes no difference to the fact that counsel is the one providing the representation. Counsel runs the show in service to counsel's client. And so the doctors don't need to be running the show in any way. And there's a legal standard to be addressed here. That's counsel's wheelhouse. Let's find out what the doctors can give us when it comes to what they understand about capacity. If the expert says this individual needs a guardian, that's maybe not the best way to start, and simply isn't the sum and substance of your conversation with the expert. What does the expert understand about guardianship? The expert may not. The expert may equate the existence of a certain diagnosis or condition with a need for guardianship without further analysis. This is true in guardianship and conservatorship proceedings, and I'm sure there are many here who have run into the same notion in the context of providing, for example, representation in criminal matters or civil matters such as a personal injury case. The expert's contribution is a valuable tool. We need to know how to use that tool. We select the tools that we want. If we're given a limited selection of tools from which to choose, we try to do so wisely in the service to the client.
Who do you look to as an expert anyway? Very often the physician who knows the patient the best is their primary care physician. Are they an expert in giving an opinion about their mental capacity?
As a fact witness, this is difficult for some doctors to swallow. I'm sorry, doctor, you're not the expert here. You're a fact witness. They may not know what that means. It's well understood in psychiatry and psychology, for example, that the service provider is not your choice as a forensic expert, the one to give some opinion relevant to a legal matter in court. But naturally, if I were functioning as the expert, for example, I would be very anxious indeed to find out what the treating entities have to say, as would counsel. Don't have to accept it, definitely want to know it.
But it is possible, Eric, for a treating physician to be both a fact witness and an expert witness in terms of understanding if somebody lacks the ability to engage in a certain transaction, if somebody if somebody suffered from a brain injury, it is possible that their team of treaters may be both fact witnesses and expert witnesses, but not the final determiner of whether that person has capacity or doesn't have capacity.
Neither
and in
would.
some jurisdictions, an expert can't opine on the ultimate determination. So that will be jurisdictional in nature.
Few things there. I couldn't agree more with the notion, and it goes across the board. Neither the fact nor the expert witness is a final determinant of anything. And an expert witness is someone who addresses that particular issue forensically in terms of informing that issue. However, the fact witness can give all sorts of useful information about what they've observed, what they've done. It may even have been a part of the treatment in, say, a cognitively based evaluation with that individual outside of this guardianship or conservatorship case, and then let us know what you did. But leave the opining, not the determination about how things are going to go, to the expert witness. Now, there may not be experts, And what I'm certainly not suggesting, I don't think anybody else would be, is that absent somebody who is the expert witness writ large, that we can't hear from these other doctors because, hey, you're not the experts. They may be displaying some very considerable and necessary expertise indeed, but they're not the expert witness. It's a notion that the doctors may have some difficulty grasping, but if counsel's persistent, they can be led to understand.
I always have some
If I could add to that, I think it's important if you're dealing with undue influence, because we raised that issue before, that if you're addressing a transaction after it has occurred, right? If that's the basis for the petition or action of the court being requested, there is a lot of case law out there that the opinion of the attorney, if the attorney was supervising the transaction, may not be afforded any less weight than the expert witness who comes in who was not present when the transaction took place. So, it's really important to understand all the parts that lead to an ultimate determination.
Indeed, and in fact, there is no requirement or even expectation that the expert witness's opinion need be afforded any more weight than anyone else's. There are many who will tell you that they really want to hear from the fact witnesses, and thank you, experts, for your time.
Take the case of Mr. Brown with 21-year-old TBI, aphasia, not a lot of experience in financial management. You're going to call any experts in, and what kind of expert?
Well, Ben, you were lined up, I think, before anyway.
No, I guess in that question, the relevant expert, if you are trying to decide whether or not she needs a conservator, then you need somebody who's familiar with TBI and aphasia. And, we're given the information that she is slowly improving. So whatever decision the court makes in that, it's not going to be a permanent decision, right? It needs to be revisited every once in a while to see. If you are making a decision specifically on the financial issue of what to do with that $4 million, then you might need expert witnesses who can testify to her capabilities with regard to finances. So it's it depends on the question, but I always have sympathy for the fact finder, be it a judge or a jury, who is asked to decide a guardianship case, guardian or no guardian, based on the testimony of expert witnesses alone. If you have two qualified doctors, one of whom says that this person needs a guardian and the other person is saying who's not, it leads to the conclusion. The fact finder has to determine which of them is correct, and that's going to involve an element of judgment. And I think the important aspect of this, if you're going to make the right judgment, there are too many guardianship cases today where the subject of the hearing is not present. And that can be because, this person's bedridden or this person's incommunicative and they're not going to be able to answer questions. But in this age of video conferencing technology that's widespread, there is no longer any excuse for the subject of a guardianship hearing not to be interviewed by the judge, or not to be at least have eyes and ears on by the judge, who can look at them and try to decide which of these expert witnesses is actually closer to the truth using their own fact judgment.
Eric, I would say, however, that's an assessment that the attorney may need to make, because if you have a client who is likely to get flustered, whether they're in court or using technology, and even if you think they need a guardian or conservator, but they're not going to present well, you're not necessarily going to want to examine that individual. And so that you want to give them the opportunity. It's their choice, really, I think, whether they want to participate or they don't want to participate. But there's a lot of different factors that go into these things. And while I wholeheartedly agree in making courts accessible through use of technology, it's just another thing, when I have somebody execute a will, I don't always video record it, because you're giving somebody else the opportunity to second guess at that particular moment, whether the way they view them at that moment translates into another moment in time, or how they will function. And so I think it's a lot more nuanced, and it requires being able to sometimes walk through a very thorny path in trying to figure out what is the best approach.
Look, from
So-
counsel's perspective, and yet when you have the judge may not really care too much about counsel's perspective and may want to do what Ben is recommending, which is to get in there and find out for themselves. Also, though it's not determinative, Kentucky's an example of one jurisdiction in which the evaluators are actually called upon to opine whether being present during these proceedings might work a hardship or even some form of potential for harm for the participant. Again, they don't make that call, but they may inform the call that's made by the bench.
One question from a participant asks, how does a medical doctor evaluate and determine whether or not a person has capacity to do a certain thing, like sell real estate, or let's take our hypotheticals, just financially manage their own money? What does a doctor know about the legal capacity for needing to selling real estate? Well, that raises a good point for how you deal with clinicians. Who would like to respond to that?
Well, I saw that one too, and I wanted to respond to it, and other things came up. That's right. I've done guardianship evaluations in jurisdictions in which they want me to state whether the individual is capable of driving an automobile, not just in terms of conducting the vehicle, but doing so safely, responding to road markings and signs, and understanding the notion of a speed limit and things of that nature. The American Psychiatric Association has specifically warned its members against providing an opinion on people's ability to drive. So point well taken from our attendee.
Yeah, I agree too. That's not a medical determination necessarily. And so the expert that you might want, what's more important is the person's relative experience with selling real estate or managing funds. And so that doesn't necessarily need to come out through expert testimony. It could come out through other evidence of their, whether they have experience with transactions previously, whether they might still have the capability to conduct those transactions. So the expert, the medical expert certainly is not always qualified to make that determination.
This gives me an opportunity to plug. There is a resource list that is available to all the participants, and you should take a look at that, because there's some really good resources that really cover things like that. I always have at my fingertips. I don't mean to plug just one, but I have it here because I've been involved with it many times, and it's not going to show up, but it's a assessment of older adults with diminished capacities that the ABA and the APA has put out. The ABA through the Commission on Law and Aging, and things like financial capacity. It has a whole chapter on that and how you would evaluate it, because it is not a simple yes or no issue. There are many domains of financial capacity, each of which may be different.
And Charlie, I apologize because I still don't have internet, so I'm, kind of on a tablet here, and I might have missed this discussion, but somebody might have capacity to do part of the transaction, or they might at some point in time in the day or week have capacity to engage in a transaction. So because capacity can fluctuate. And so you really have to look at it at the time when you're dealing with that real estate transaction as to whether they had sufficient capacity to engage in it. And it may depend on how complex the transaction is. What is at issue in that particular transaction? If they had capacity to enter into a sales agreement with regard to their house, and you're now just going to the closing, that may require a little bit, as long as they're functioning pretty well, that might be different than what they needed to negotiate the terms of the deal. So we have to be careful that we don't lump a category into one basket without looking at each of its elements.
Yeah. Now, one person asked, what is the role of functional capacity versus legal capacity? And that actually blends a couple notions together. Eric, do you want to try to address that?
Functional capacity gets right down to what someone can or cannot do, as demonstrated in the past, as assessed currently, as projected in the future based on a skill set that we may be able to identify. What can you do? And then there's going to be a legal standard that to some extent is likely to incorporate that and a number of other things too, and not perhaps that specific capacity. The person who provided this question is helping us out a great deal by highlighting one of the major problems that you can have when the experts are dispatched to do their jobs. Don't come back and give me a diagnosis that you think prevents people from doing something. Have them do it. Ask them how they would go about doing it. Give them situations in which somebody has done something. Does it appear that that individual has done it properly? And this is similar to the notion that was raised earlier about ceding control to the expert and educating the expert. Counsel needs to be in charge of this process and make sure everybody knows these differences.
To add to that, if I could, Charlie.
Sure.
I had an expert in one case who came to evaluate the court in Michigan. We don't necessarily call them visitors. They'll automatically appoint a GAL in these cases, and then they may or may not appoint an expert to go and evaluate the individual. And in this particular instance, the expert went out and they were trying to decide whether the individual had sufficient financial capacity. Well, they never asked. They asked her to balance her checkbook, but did not provide her with an adding machine. She had always used an adding machine in order to balance her checkbook. She was never good at math, right? So if when you have an expert who does that, you really have to dig into what did they do, and you have to know how your client historically functioned. So if they historically relied on support, i.e. the calculator that was just raised, or some other, maybe they do online banking and they have a link that lets them get into their account automatically, and the bank automatically balances their checking account when they issue a check out of that account. You have to know the historical practice of the individual and whether they're still able to do that, as opposed to coming in and just doing a standard test by an expert that has no basis in how the person has previously operated.
That's a great point, because it makes a really important point about legal capacity, which looks at, okay, even if you can't do something, are there ways that enable you to do it through technology, through supported decision-making, through other legal tools? And the classic example of that are the two individuals who have advanced Alzheimer's, clearly cannot manage their own affairs, but one, while they were capable, had done a trust and a power of attorney, and they have everything taken care of. That person doesn't need a guardian, and the court should not find them legally incapacitated and appoint one, whereas the other person who doesn't have any of those aids in place may need one. So really an important point. And let me make sure we adequately give attention to our last mistake that we want to take a look at. I'll go back to screen sharing here. And overlooking key details in trial preparation. And Sandy, let me start with you on this one. Both you and Erica are very well experienced in this area, but Sandy, how is it that guardianship, conservatorship litigation is different from other litigation in terms of preparation? And what is it that gets overlooked?
Well, sometimes our clients don't even realize what information may be available from other sources, because they may have diminished capacity while they still have capacity, and they may not be as good at problem solving. So we may have to look to other sources for gathering information in order to determine what kinds of proofs or evidence we can place on the record that might be of assistance to our client, and make sure that, when I do commercial litigation, I may be interviewing my client and they're telling me all the sources and all the things they think will help them. And when we're dealing with vulnerable adults, we may have to assist them and lead them into consideration. Well, do you have a neighbor who might know how you function? Can I speak with that individual? Who are your treating physicians? Do I have permission to contact them? Will you sign a release so I can get your medical records? All these kinds of things as part of the prep. Can I talk to your family? Are there members of your family I should talk to? Are there others I should not talk to? But setting forth options for our client that they may not be able to self-generate in order to help in the preparation of the case, it can be really key. And then also strategizing. I think that people often forget in some jurisdictions that a guardianship case may be entitled to a jury trial, and assessing whether your client might do better with a jury than a judge, if you know that the judge is predisposed to granting plenary guardianships. You might be able to pull on the heartstrings if you're representing the individual and lay out the dynamics of the family and what other individuals are doing, and maybe they have ulterior motives for wanting the guardianship or the conservatorship. You might do better with a jury than you might do with an individual. And then another aspect is, under some state statutes, you may request a closed hearing when you're dealing with a guardianship, and you may not have that option when you're dealing with other types of litigation. Generally, civil litigation, your courtroom is always open unless the court has issued a protective order. In a guardianship, it's the reverse. The courtroom is deemed to be open, but the individual whose rights are being adjudicated has the right to ask for a closed hearing in many jurisdictions.
Eric, what do you want to add?
Briefly, that we've paid a lot of attention, and appropriately so, to how it is that one prepares the expert to conduct the evaluation about the right issues and in the right way. And when we talk about preparations for trial, it's also necessary to get with one's expert prior to trial. Yes, you have their report if a report is required and or proffered, but what do they actually understand? If the stakes are high enough, when someone might say, show me a case where the stakes aren't high enough. What if it were, if you were related to Ms. Gray or Ms. Brown? One of the things that you may want to do is to run your expert through a bit of cross-examination on these topics. Now, as a matter of attorney expert dynamics, you may not be the one who actually conducts that exercise. If you're doing your job, you may lose a little bit of that relationship. Maybe someone else in your office, someone in the adjoining office, someone who can give your expert a sense of what it is that they might be facing in this particular matter, and make sure they understand what's going on, make sure that they're prepared. And little things can mean a lot. Make sure they know where the courthouse is and where to park and how early they need to get there, and whether your judge wants them to speak up. other things too numerous to mention in our time. But it's not over with your experts once you get their report and you think you like it.
I would say that a lot of people say, you know, probate court is less formal, it's a friendly environment, you know, but it's still litigation. So discovery is still a component of these cases. Understanding, if you get a report from an expert, you know, somebody appointed by the court, understanding what they did, reviewing it, understanding how you should cross-examine that individual, and coming prepared with alternatives. So your expert may not have come with alternative solutions. So you might have to argue, Your Honor, we don't believe a guardianship is appropriate under these circumstances. If the court is inclined to grant a guardianship, we would argue you should consider X, Y, and Z as alternatives, as opposed to granting the petition, right? So being creative in terms of evaluating options while you're preparing your case, and perhaps having witnesses available that will support the availability of those alternative options, can all be part of your trial prep. It can be very important.
And state cases of Mrs. Gray and Mrs. Brown go to court and you're representing them, the respondents. They seem capable of getting to court. There are some clients you can have who are not going to be able to come to court, and that's the separate issue. But are you going to put them on the stand?
It depends, right? On a case-by-case basis, with the same considerations we encounter in any other kind of litigation. I want to throw in something too that we all discussed earlier, germane to this topic, that probate court is not the place for the large firms or any other firms to send their early career attorneys to see if they're capable of handling trials. That's unfortunate, and I've seen that in some jurisdictions. These are not lesser cases. They are by no means necessarily less difficult cases. Let's try to keep the same experience mix in probate court that we do in other venues.
But isn't one of the issues the respondent's ability to pay you? I mean, and I think many lawyers struggle with the ethical issue of really how much can I do for this client if I'm going to end up doing it pro bono, and how much can I do pro bono as opposed to getting paid for it.
You make that decision up front. You don't make it once you've accepted the case. Gee, this seems like it's going to be an awful lot of work. And if we're on the front end of getting involved in pro bono work, it's worth reaching out to a colleague and asking them how much and what it takes. I hope this doesn't sound like some judgment delivered from on high about people who are willing to donate their time. Those people are heroes, but they should consider what the cost of heroism can be and how likely it is that they're in a position to pull it off.
Well, we have a duty of competency as attorneys, right? And if we lack sufficient competency to provide the legal services required by our client, then we have to gain it. We have to partner up with somebody, or we may have to decline representation. So when you give the scenario of the new associate who's been assigned this case, well, then you may have a partner or a more experienced litigator in the firm who can provide guidance and should be partnering up with that individual in order to help. There's nothing wrong with this being a learning experience and mentoring experience, as long as you have the backup of an experienced attorney who's able to provide the necessary guidance and direction.
Yes, and that's what I meant by the mix of experience. Same exact rules for the doctors, by the way.
As we're getting close to the end, first of all, Ben, I want to ask you, is there anything that the Uniform Act or state laws in general say about trials or pretrial work that is different or unique to guardianship and conservatorship?
Well, I think the difference is in the who serves in that role of the visitor. In states where it's always a guardian ad litem who provides the report, that person's experience is generally legal in nature and not necessarily with the condition that they are inclined to evaluate. To use a very simple example, if you are evaluating somebody who is deaf and has always lived independently, you're going to have a hard time communicating with that person unless you send somebody out who is able to communicate with the deaf, or you send a translator with them. And it's kind of garbage in, garbage out. The report is not going to be indicative of the person's true capabilities unless you find somebody with the right qualifications to make that evaluation. That's why the term is the visitor is used, kind of the generic term in the Uniform Act, and then further defined in the Uniform Act as somebody with the experience and or expertise to make the appropriate valuation of the individual whose guardianship is being considered.
That segues to a question which will be our last question, but it has to do with, leads off the comments you just made, Ben. The question is, how do you overcome the court's, no, wait a second. My thing scrolls down without letting me read what I wanted to read. Any tips for combating all the hearsay of the guardian ad litem report and testimony? It seems like most guardianship proceedings rely solely on the guardian ad litem report, which is essentially uncontested.
Well, the fact that the questioner is terming it as hearsay indicates that it's probably a problem in that jurisdiction. The resources that go into making a good report are, not all courts have them available, and so some of the creative things that you can do is you can provide your own evidence. If you don't like what's in the GAL report, have your own witnesses, people who are close to you, who understand your condition and available to testify at the hearing, who can perhaps make the argument that the GAL's report isn't necessarily based in fact as they have seen it.
Well, and if I could, this may be a problem jurisdictionally in some areas where the GAL report is automatically admitted into evidence. A report is not necessarily evidence, right? The report is the individual's opinion or a report of information they obtained. And it may even contain hearsay within hearsay, right? Multiple tiers of hearsay within the report. And as you said, Ben, providing some direct evidence or even having the ability to cross-examine, whether it's a GAL or a visitor. Well, how did you obtain that information? Who did you provide it? You don't know whether that's true or not, do you? If you didn't independently witness that kind of behavior or inability to engage in a transaction or whatever's reported in the report having occurred, right? You're just relaying that information. And it may be important to remind the court when you're dealing with expert testimony that while experts often rely on other sources of information in providing their opinion, you need to ultimately have the underlying evidence upon which they're relying on their opinion entered into evidence.
And with that comment, because we have to end right on time, I want to wrap it up here. Again, these are the 5 mistakes we covered. And you do have access, I believe, to the slides, but don't overlook the resource materials that are also attached. They're quite valuable in going deeper into everything we've discussed today. So thank you for joining us for this free webinar today. We'd like to express our gratitude to the wonderful group of experts we have to speak with before you today. You're all out there doing such critical work, and we thank you for taking the time out on your schedule to share your experiences. The section on civil rights and social justice provides free webinars and resources for legal professionals and advocates nationwide. We hope this helps you in your work. And again, if you can, please consider joining and becoming an active in the ABA. You may do so at americanbar.org/CRSJ. I also want to thank our co-sponsor, the Commission on Law and Aging. Best of luck in your work and stay safe